So here we go. How do lawyers sleep at night? It's a joke, and perhaps I'll tell you the answer to it at the end of the lecture. But we're going to talk about law and medicine, the intersection of the two. And I do have some conflicts of interest to declare. Firstly, what I'm going to tell you, a loose bunch of anecdotes tied together very loosely by a theme, that I'm not entirely disinterested in this subject, as I do derive some small income from my medico-legal practice. I'm actually legally qualified as well, so secretly I'm a lawyer as well. And I've even worked as a deputy coroner. So I'm likely to be nicer to lawyers than you perhaps would be in my place. Getting checks from lawyers is a wonderful way to realise what tremendously good chaps they are. But here's the question I'm going to ask. Are lawyers good for patients? A simple enough question. And I'm not sure I'm going to come up with an answer at the end of it, but we're going to illustrate it by looking at various aspects of the law as it has been applied to medicine over the last few years and see where it takes us, and indeed somewhat earlier than that. Not quite as early as this illustration, which I've used to illustrate the proceedings in a civil court of law. And most of us, if we have dealings with lawyers, will be in the civil courts when we are faced with a claim for negligence. However, let us go back a little bit to even before the start of my anaesthetic career, I think, 1977, yes indeed, I was only 20 years old at the time, when a gentleman called Dr Kerr published an interesting case series in the British Journal of Anaesthesia describing profound hypotension for middle ear surgery. He was working with a surgeon who did middle ear surgery through a microscope, as is still done, and liked to have a bloodless field. And Dr Kerr was delighted to try to present him with as bloodless a field as he could possibly achieve. To this end, between 1969 and 1974, he anaesthetised 700 patients and reported them in this paper. But there were 500 patients before he started to collect this series, so that's 1,200 before we begin. And of the 700 he reported, he was trying to achieve a systolic pressure below 50 millimetres of mercury, and he was trying to do it for the average length of time it would take for a mastoid procedure, one of which I've actually anaesthetised for this afternoon, which is about 1 to 2 hours. I know, and most of you here aren't even anaesthetists, and even you know that's quite a low blood pressure. Well, look, here's table 1A, and you can see that this is the table of patients in whom there was satisfactory hemostasis, of which there were 280 out of the number that he reported, which is a fair old number. You may see all the things you think he might have controlled for, he didn't really control for. So the age of the patients, for a start, there's a fair chunk there who are more than 60 years old. He's trying to get the blood pressure below 50 systolic, but in some cases, in fact, in the majority of cases, had a systolic pressure between 40 and 50 millimetres of mercury. But there were a substantial number who had a systolic arterial pressure of between 30 and 40 millimetres of mercury for 1 to 2 hours, 39 of them in total. And indeed, you can see there's a chunk beneath that who had a blood pressure below 30. And all went reasonably well. This is what he reported. The arterial systolic pressure, which gave the most satisfactory hemostasis, was 30 to 45 millimetres of mercury, and a few patients' operating conditions were satisfactory above this value, and a few bleeding occurred in spite of pressures in the low range. I like in the low range. In spite of the arterial pressures being reduced to very low values in many instances, there was no mortality or morbidity which could be ascribed to the technique, a phrase that came back to haunt him, particularly in terms of the phrase, in spite of the arterial pressures being reduced to very low values. Because in 1979, 2 years after this paper was published, and by which time 1,500 patients had been through this process, he got to anaesthetise Mr. Hepworth. Mr. Hepworth had a mastoid procedure and developed a large stroke following anterior spinal artery syndrome and sued his anaesthetist, an unusual thing in the 1970s. Mr. Justice McKinnon was not swayed by the paper in the British Journal of Anaesthesia. Many people were swayed by the paper in the BJA. In fact, I looked back at the BJA for the year following that paper's publication to look for all the letters of protest that were published saying, you must be bloody mad doing that. And there were 2 letters published with regard to the paper, one of which said, that's a little bit low, isn't it? And the other one said, you really should have used an ECG to monitor the heart if you're going to do that kind of thing. That was it. Mr. Justice McKinnon was a bit wiser than this, despite taking evidence from 5 expert anaesthetists, all of whom said it was a jolly good idea. he found that the Mr. Hepworth's systolic pressure had been lowered to 40 millimetres of mercury or below for 1.5 hours, and said, quite wisely, the defendant, that's Dr. Kerr, ran the unnecessary and foreseeable risk of causing injury to the plaintiff by underperfusion of major organs. He said he expected cerebral or cardiac thrombosis. After all, you go back to the paper, it says, in spite of low blood pressures, it almost says, I was a little bit surprised to find that none of them suffered any harm. And he also went on to say, I simply cannot and do not accept the defendant was justified in doing what he did without proper scientific validation of his technique. This despite the fact that Kerr had done what a lot of doctors hadn't done and at least published them in a reputable journal. And the BJA is a very reputable journal. The judge there got it right, where all the scientists had got it wrong. People had ignored these very strange reports by Dr. Kerr, these astonishingly low blood pressures, let him carry on with his work, and the only person who questioned it was a judge. It's not normally like that, though. The law is not normally that good at this sort of thing. And to illustrate that, I go back even further now to the mists of time, to Woolley and Rowe, two names that will strike fear into the heart of any anaesthetist and whom nobody else in the room has ever heard of. Messrs. Woolley and Rowe were two patients on an elective operating list on a Monday morning at Chesterfield Royal Infirmary in 1947. Sorry, Chesterfield Infirmary. It wasn't a Royal Infirmary. One of them was having his piles operated on. There was a lesion in his rectum, and the other one was, I think, having knee surgery. And both had a spinal anaesthetic, as was completely normal in the 1940s. Up to the time of these cases. And both of them separately developed a gradual severe paraplegia, which left them one paraplegic and one quadriplegic, shortening both their lives quite considerably, following the surgery, in the days following the surgery, in fact. And the second patient on the list between Mr. Woolley and Mr. Rowe also died in the following days, but didn't appear to have demonstrated the same problems despite having had a spinal anaesthetic. But he may well have had it in retrospect. And the paper is worth reading. Should you go back, you'll find it online in the 1954 issue in October of Anaesthesia, not the British Journal of Anaesthesia this time. It's a very good paper. It runs to 22 pages, and Dr. Cope is essentially describing what it was like to be an expert witness in this case. And I do recommend it. The judge found that what had happened was that the glass ampoules of local anaesthetic used to, which had been administered intrathecally, had become contaminated through microscopic cracks in the glass with the phenol solution that had been used to sterilise the outside of the ampoules. Phenol had got through microscopic cracks, and that's what had caused the severe arachnoiditis that led to these disastrous outcomes. And therefore he found that the anaesthetist had not been negligent in his practice, and Mr. Woolley and Mr. Rowe never got any compensation at all. Now, this is almost certainly completely and utterly wrong. Firstly, because phenol is actually used in the concentrations that would have got through microscopic cracks in the glass in spinal injections to treat chronic pain, or was at that time, and didn't cause this sort of reaction. And in any case, why did it affect those two patients, or possibly those three patients on that one operating list, and no other patient having spinal anaesthetic in the United Kingdom? It made no sense at all. And one of our colleagues here, Dr. Hutter, who's now retired, is a bit of an anaesthetic historian and detective, and he decided that what had happened was that the needles and syringes which had been used had been boiled in the autoclave, not in water, as was supposed to have happened, but in a solution which had been used to descale the autoclave device over the weekend. They'd used a descaler, highly acidic descaler, and that's what had got into the intrathecal space, and he was almost certainly right. The trouble is, not only did the judge get this one wrong, but the impact was quite remarkable. And this is reported by Scott and Thorburn in the BJA 20 years later. They said, they reminded us, although the popularity of spinal anaesthesia continues unabated in many parts of the world, it has been virtually ignored in Britain in the last 20 years. Since the Woolley and Rowe case, in which two patients developed painful and persistent paraplegia, the use of the technique in the United Kingdom has been confined to a few enthusiasts. Those of you in the audience who are urologists, urological surgeons will find this hard to believe. But really, until the mid-1980s, we did not do spinal anaesthesia in the UK since the Woolley and Rowe case. And we still remain the lowest one of the lowest users of spinal anaesthesia in Europe today. There's still a race memory. There's a bunch of elderly patients out there. If you say we're going to put a spinal anaesthetic, you say, well, don't do that, I'm going to get paralysed. They remember this case. But the impact this had on British anaesthesia, with almost certain major morbidity from inappropriate use of general anaesthesia, was immeasurably large. And this is because, as I say, lawyers aren't very good with science. I once spent it was probably about 40 minutes, but it felt like 4 hours, trying to explain to a judge in open court why, if you took a pregnant woman and tilted her at an angle of 30 degrees, the weight of her gravid uterus upon her blood vessels would diminish by a factor related to the cosine of the angle at which she was tilted. Now, this is actually pretty straightforward GCSE physics, but believe me, there was no way of getting this one across to the judge in any way, shape or form at all. And I gave up eventually. It's not surprising, is it? Judges are not scientists. This is the Supreme Court as it currently stands, with Lady Justice Hale resplendent in the middle. And only one of these very eminent people has got a degree that contains the word science in it. And it is Lord Kitchen back there, who has got a degree in law and natural science. That's it. There's the only one. The rest are all law, jurisprudence, English, history, etc. The liberal arts. Furthermore, the law is not designed to test scientific theory. If we were to look at a scale of likelihood where the far left-hand end is unbelievably unlikely, and the right-hand end is surprisingly likely, the test in civil courts is a 50% test on the balance of probabilities. And that's not what we use in science. We like to look at the p equals less than 0.05 figure, which is 95% certainty. Now, admittedly, in the criminal courts of law, that's the sort of level which they apply the beyond reasonable doubt test. It's been described as anything between 90 and 99%. But we do not want to be tested in the criminal courts, as we will see later. So it's not really a good place to test science anyway, and therefore not a very good place to set medical practice. But let's leave that alone for the moment and look at 4 women who have been very important in my life. And I will use their cases to illustrate a few other points. And the first of these is Angelique Sutcliffe. Angelique, as you can see there, is being pushed in a wheelchair. And in 2001, Angelique underwent spinal anaesthesia. I'm sorry, it recurs a few times during this, for a caesarean section. She'd had a previous spinal anaesthetic for caesarean section, which had been fine. She had a spinal this time. She reacted rather oddly in the middle of the operation, though the operation was eventually completed, albeit under general anaesthesia. She was a little bit odd in the next few days, but recovered sufficiently to go home, but was readmitted 3 days later with urinary retention, which never got any better. And then gradually, over the next 2 weeks, she developed a progressive paraplegia and then raised intracranial pressure, necessitating a series of major neurosurgical procedures to decompress her ventricles. She had, I think, 6 separate procedures in the end. And her MRI scan looks like someone has taken her spinal cord and split it from the bottom upwards with an axe. I've never seen anything quite like it. And we have no idea why Angelique suffered this appalling reaction that was almost certainly related to the spinal anaesthetic. And it was 6 years before it came to judgment. The headlines at the time were pretty toxic, as you can see. And they were toxic because the judge concluded that Angelique, what had happened to Angelique was that a tiny part, but measurable part, more than 0.1 mil, of the 0.5% chlorhexidine and 70% alcohol used to clean her back had contaminated the spinal injectate, and that tiny bit of chlorhexidine had caused the appalling adhesive arachnoiditis which she suffered. Now I was instructed in that case as an expert for the claimant. I could not have concluded, I didn't conclude that. I said, I can't see anything that's gone wrong in this case. The whole technique had been described, the fact that chlorhexidine had been kept separate from the injectate and everything else. It seemed incredibly unlikely to me, and I said so. So they sacked me and instructed somebody else, which is what they do on these occasions. I was sufficiently surprised by this ex cathedra judgment, which at least got Angelique the money she deserved. I was surprised by it to write a rather stinging article, as you do, in Anaesthesia News called The Truth, the Whole Truth, at a time when I looked much younger. And I said, really, I think this is quite extremely unlikely. We don't know what happened to Angelique, and we still don't know what happened to Angelique. And in this, I was wrong, and the judge was right. And the reason I say that is because of this lady, my number 2 lady here, Grace Wang. So in June 2010, Grace Wang was delivering her first child by a natural childbirth in a maternity hospital in Sydney, Australia. And she wanted an epidural. Grace had her epidural, and on the epidural trolley there were 2 pots of open fluid. One was the antiseptic used to prep the skin, 0.5% chlorhexidine and 70% alcohol. The other was the normal saline used to locate the epidural space by injection, loss of resistance to injection. Both were in identical pots. One was pink and one was clear. So what unfortunately happened is that the anaesthetist tried to do the epidural, got some blood back through his syringe, contaminating the saline, squirted the saline back into the saline pot, and now had 2 pots of pink-coloured liquid. He then drew the fluid out of the wrong pot to locate the epidural space. And Grace, we know for certain, Grace had 8 mils of 0.5% chlorhexidine and 70% alcohol injected into her epidural space. And probably some of it went into her spinal space as well through a dural puncture. And what happened to Grace was exactly the same as happened to Angelique. Same time span, same impact. Her paraplegia actually extended somewhat further than Angelique, so she had difficulty even holding her baby some months later, and she ended up following steroid therapy and surgery and so on, looking a very different woman indeed. But we knew she'd had chlorhexidine in her neuraxis, and the same thing had happened to her, and the judge was almost certainly right in ruling about the chlorhexidine, and I was almost certainly wrong. It's a nasty business, adhesive arachnoiditis incidentally. That's what a transverse MRI scan of the cauda equina is supposed to look like. And these are 2 scans taken from other patients who have suffered severe adhesive arachnoiditis. And you can see just how the nerve roots clump together before the cord starts to split. So what happened as a result of this case? First of all, I wrote a cringing apology in an editorial in Anaesthesia to the judge who I'd wronged in the first one. Secondly, the Association of Anaesthetists, along with other organisations, we came together and wrote guidelines for skin antisepsis for central neuraxial blockade to ensure that chlorhexidine was kept well away from any risk of contamination. Thirdly, there was a patient safety alert in 2007, which finally stopped us from drawing fluids from an open container up into a syringe. So none of us are now allowed, none of us, allowed to draw fluids from an open container into a syringe. Although some of that arose from our radiology colleagues who were drawing all sorts of strange things up from open containers into syringes and accidentally injecting them. But again, this is a case where the judge got it right, but it's an unusual case. And I don't think that's how we learn on the whole. Generally speaking, I don't think we learn very much from civil litigation. We should do, and I'm starting a campaign where we can learn from the law in this way. So I've analysed my own medico-legal database of 750 cases, looking at 76 cases of patients who have felt pain during caesarean section, and analysed those and written a paper along with a colleague, trying to develop some learning from it. But it's very unusual for the medical profession as a whole to learn from the law in this respect. But even if we did learn from the law, it's an expensive business. So this is last year's Financial Times, which is reminding us of the cost of civil litigation to the NHS. And here you can see it's quadrupled from 2006 and 7, when it was 400 million, to 1.6 billion spent on clinical negligence scheme for trusts in 2016 to 17. Astonishing. And at the same time, legal costs have risen from 77 million to 487 million. And that's the problem. If all of this money had gone to to helping patients who had been harmed in the NHS, it would still be very expensive, but at least they would be getting some help. But of course they aren't. A lot of it's going to the lawyers. Some of it's going to me, but not £487 million. And actually that is 30% of the total payout of 1.6 billion has gone into the pockets of the lawyers. And none of us like lawyers very much for that, but to be fair, that's their job. But it's still going up. So until last week, I was able to claim, though I very rarely said it, that I was the expert in the case that had cost the NHS more money than any other case ever settled against it. But I'm not anymore, because this was reported in the Times a couple of days ago, and this was a neonate who developed herpes simplex, which the neonatologist were 2 days too late to diagnose and finished up with very severe brain damage. And this award of £37 million is now the greatest single award against the NHS. I mean, that will buy a lot of nurses and hip replacements, frankly. And it's very difficult to imagine that we learn enough from the law to warrant that sort of payout, especially when much of this child's care, as he grows into adulthood, could be provided by the NHS at much lower costs than this. But that's the way the law works. Let's talk about a branch of law which has interested me greatly over the years, so much so that I actually became one for a period. Coronial law. I rather like this cartoon. The juror says, "The man's alive, sir, for he has opened one eye." Coroner, "Sir, the doctor declared him dead 2 hours since, and he must remain dead, sir. So I shall proceed with the inquest." Coroners. Of all the courts you end up in, I hope you don't end up in the coroner's court. I've sat as a coroner, and I've given given evidence in coroner's courts, and they can be difficult places. Coroners can be useful to doctors. I really do think so. I'm often rather damning of coroners because of the variation in their quality of practice around the country. But they do occasionally come up with important stuff that we need to learn from. So this was reported in Anaesthesia News a couple of weeks ago. And it's a reminder, written by two of our colleagues here from Nottingham, that what it tells us is that, as a result of an inquest carried out, the coroner has written to the Association of Anaesthetists and the Royal College of Anaesthetists, asking them to remind everybody, or to teach everybody, that if you put a tube down the trachea, even in a patient who was arrested, and you then blow air into and out of the lungs, they will put out some carbon dioxide, which will be measurable on the capnograph, the carbon dioxide analyzer that's always attached to the tube. So the top trace there, for example, is the trace of a patient who is receiving CPR, having arrested, with a tube down their trachea. And the bottom trace is actually the trace of a patient who is not getting cardiac massage, is just being ventilated, having arrested, is still producing CO2. In other words, we can use our method of determining tracheal placement of the tube, production of carbon dioxide, even in a patient who's arrested. In the case that the coroner was describing here, a tube was inadvertently placed down the esophagus in an arrested patient, and the lack of CO2 trace was ascribed to the fact that he had arrested. And it's not true. Even if he had arrested, if the tube was in the trachea, we would have seen CO2. It's very good of the coroner to remind us of this. We probably need reminding. We knew it anyway. We knew it because we'd carried out a massive nationwide audit of airway management in the United Kingdom, and there's an entire chapter devoted to this particular aspect of it. But an occasional reminder from a coroner is not a bad thing. And coroners were also involved in my last two ladies here. On the left is Pauline Edwards. And Pauline Edwards was 52 years old when she underwent routine elective gynecological surgery at a hospital in London. I've got a whole lecture about what happened to Pauline, and we're not going to have it here. But essentially what occurred was she was being cared for by an anaesthetist who, although having passed through all the training in their own European country, was still relatively untrained by British standards, but had come over to another European Union country, us, to work as a cardiac anaesthetic fellow, to learn about cardiac anaesthesia, was employed as an equivalent of a fifth year, an ST5, so a senior registrar in this trust in London, and had been asked to go and take over the gynecology list because the consultant had phoned in sick. And if these patients weren't operated on, the waiting time limits would have been breached. So she went down somewhat reluctantly to a theatre she'd never worked in, encountering an anaesthetic machine she'd never worked with before, and a team she'd never worked with, and the surgeon who didn't know her. And at the end of this operation, which became a bit prolonged because the surgeon was unable to complete it laparoscopically, so it went on into the evening, she found herself, unbeknownst to her, working alone in a small group of theatres where all the consultants in the adjoining theatres had gone home, and there was nobody supervising her. And she pulled the tracheal tube out, and the patient developed laryngospasm and died. But she just did not in any way resuscitate this patient. Over a period of 27 minutes, she became more and increasingly hypoxic. We know this because we have the photographs of the monitor screen that were taken by the consultant who sadly arrived far too late to save her, that photographed the screen before they left theatre. And it was a failure of training, but the main thing about Pauline's case was it was an appalling failure of supervision. The anaesthetist had no idea that she was on her own. She didn't know who, if anyone, was supposed to be her consultant supervisor. There was a consultant elsewhere in the hospital who was troubleshooting any lists that were still going on. She didn't know that this anaesthetist was still working by themselves. There were still lists going on in this isolated group of theatres. And by the time she was contacted, it was far too late. It was a major failure of supervision, and the coroner identified it as such. And on your right, you have a face which you may have seen in the newspapers last year, Frances Cappuccini, a teacher from Kent. And Frances was 32 when she gave birth to her second child by caesarean section, perfectly straightforwardly. She bled afterwards, not a huge amount, but she did bleed. She had to go back to theatre. She was given a general anaesthetic by a very junior staff grade doctor who appeared to have no supervisor either. And the same thing happened to her. He extubated her at the end of surgery. She developed laryngospasm, negative pressure pulmonary edema. Nobody took the basic step of re-intubating her and ventilating her lungs, and she died of severe hypoxia about 2 hours later. And that was a case, you may recall, where 2 anaesthetists and 1 trust were charged with manslaughter. The trust was charged with corporate manslaughter, the only charge of corporate manslaughter against a trust so far in the UK. The judge instructed that all those charges were dropped for various complex legal reasons that I won't go into. But the coroner's case, and I was involved in all of her cases, the coroner drew the conclusion that the main reason she died was the fact that this junior anaesthetist, was not supervised by any consultant at all. Indeed, I've been investigating the case for civil claims, criminal claim, coroner's claim, over a period of 4 years. And I was never able to identify, nor were the hospital, when we asked them for information, who was supervising that anaesthetist at that time. These were both deaths due to failure to supervise. And as a result of these coroner's reports, things are going to get better. So I wrote an article in the Bulletin of the Royal College in March this year describing a test which the Cappuccini family have allowed me very kindly to name after Frances. It's a simple audit which tests to see how well junior anaesthetists are supervised at any time during the day or night. It's a great audit, I really like it. It goes like this. 5 questions in the Cappuccini test. So you find an operating list being carried out by a trainee or a junior SAS grade, and you say to them, who is supervising you and how do you get hold of them? You then use the answer to number 2 to try to get hold of the supervising anaesthetist. Did this work is question 3. Did you get hold of the supervising anaesthetist? And when you get hold of them, you ask them, who are you supervising and what are they doing at the moment? That's it. It's a 5-question audit. It can be done in the space of about 2 or 3 minutes on any one list. And I'm very pleased to say we did the first one here in the world at City Hospital. Second one was done at Queen's Medical Centre, and it's now been done by all the members of the Council of the Royal College of Anaesthetists, and we're collating the results at the moment. We intend to use this as a way of driving better supervision of junior anaesthetists, but what's going to be really interesting is when we roll it out to other specialties. I'm kind of looking forward to that. So these coroners have, I think, potentially improved the way medicine works and drawn our attention to some bad things. But what about human rights and ethics? Surely the courts lead us in that respect. And for that I turn to the ladies now and gentlemen who you saw earlier, the members of the Supreme Court. And you will recall that they recently ruled on a case which has caused uproar in the medical profession and great concern, the Montgomery case. And there you see Nadine and Sam Montgomery. In 1999, Nadine gave birth to Sam. She was a small lady and he was a large baby. She had concerns about her risks of vaginal delivery, and they were recorded, but she never specifically asked about the possibility of caesarean section or shoulder dystocia. The risk of shoulder dystocia was actually quite high for her, 9 to 10%, although that with the risk of harm to Sam would still have been very low. But the obstetrician never warned her of this risk, even though she was a diabetic woman with a large baby on board. And the obstetrician said they didn't warn her because if she did that, everybody would want the caesarean section. It's not in the mother's best interests. And it took a long, long time to come to the court, the Supreme Court, and it came in 2015, 16 years later. So Sam is 16 in that photograph. And this is what the justices said. There is no reason anymore to perpetuate the application of the Bolam test. We all know about the Bolam test, the reasonable doctor test, in the context of consent any longer. The test of materiality is whether a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor should reasonably be aware the particular patient would be likely to attach significance to it. In other words, we don't judge whether consent has been appropriate by the standard of the prudent doctor. We judge it by the standard of the prudent patient. And this has caused considerable concern in the medical profession. And I rather put myself in the line of fire when I wrote another, I do like writing, editorial about this called Paternalism and Consent Has the Law Finally Caught Up with the Profession? And in this, my colleague Kate McComb and I argued that actually Montgomery had not led the medical profession in any way at all to a better standard of ethics, but the medical profession had achieved that standard of ethics long before the law had said it was mandatory, and that actually Montgomery made very little difference. In our evidence, we adduced these two leaflets, the top one by the Association of Anaesthetists on the issue of consent from 2006, before Montgomery came to be. And it says the amount and nature of information should be disclosed to the patient should, as far as possible, be determined by the question, what would this patient regard as relevant when coming to a decision about which, if any, of the available options to accept. This was reflected in the GMC's own booklet 2 years later, as you can see down there. So once Montgomery was reported, you would think the next iteration of the booklet from the Association of Anaesthetists would be considerably different, and it wasn't. So here's the 2017, and the only changes in that sentence, as a result of Montgomery, were scrubbing out the words as far as possible and inserting the word this particular patient instead of this patient. That was the only change that we made, and this was a panel of expert anaesthetists, ethicists, lawyers, and jurists, and patients. In other words, we had led Montgomery, and Montgomery hadn't led us. And this isn't just anaesthesia. This is the same in medicine generally. We've been relying on the prudent patient for some considerable time. It's only now the law tells us we must, but we've been doing it anyway. And if we didn't do it, we'd have fallen foul of the GMC. So I don't think the law tells us how to run medical ethics better, generally speaking. But finally, doing all right. The criminal court. That is, of course, Helen Archer in the dock for murder, as drawn by a court reporter, which I just love. If you're a fan of the Archers, you'll get terribly excited by that. But we should not jest about the criminal court, because the criminal court and medicine intersect in the question of manslaughter. And of course, you will all be aware of the case of Dr. Hadiza Bawa-Garba and her patient Jack Adcock, and the traumas that she has gone through and that Jack Adcock's family have gone through following his unfortunate death. But how short are our memories? Anyone remember these two? Thank you, Wayne Jowett, yes, hematologist. Oncologist, sorry. Wayne Jowett on the left-hand side and Dr. Feda Mullem on the right. January 2001. I know that Dr. Bawa-Garba was down the road in Leicester. Feda Mullem and Wayne Jowett were right here in Nottingham at the Queen's Medical Centre. And Wayne was an 18-year-old with acute lymphocytic leukemia in remission. He was on maintenance therapy of intravenous vincristine and intrathecal cytosine. And he turned up a little late one day for his regular dose. Dr. Mullem was a registrar, and I think his third or fourth day of practice in Nottingham, having trained in Leicester. He'd had no formal training in the administration of chemotherapy at all and had a new SHO working with him. Due to a series of errors, Dr. Mullen ended up in a position whereby he was instructing the SHO, who was doing Wayne's lumbar puncture, to insert the cytosine, which he gave, to also administer the vincristin intrathecally as well. That led to Wayne's death, inevitably led to Wayne's death. I think it was a month later, it was quite a long time, but it was a long and painful death. It's a gradual neurological collapse, essentially. Whatever, they tried to wash the vincristin out of his intrathecal space, it didn't help. And I say inevitable death because it's the same death that had occurred in 13 of the 14 previous cases in the United Kingdom. Remarkably, once people started to look back on it, this was a thing that happened at intervals fairly regularly, and that's over a 12-year period. So this was a thing that had been going on for some time, and it doesn't just happen in the United Kingdom, though everyone thinks it does. There are cases all over the world of vincristin being given intrathecally and resulting inevitably in patient death. There was a major inquiry carried out by Dr. Brian Toft, who's not a doctor, but a safety expert, and quite an annoying man. I've spent far too much time with Brian, who described quite correctly a complex amalgam of human, organisational, technical and social interactions leading to the fatal injection. Does this sound familiar? Those of you who have been following the Bauer-Garber case, this sounds remarkably familiar. All those factors impacting upon Hadiza Bauer-Garber as she made her fatal errors. And the same thing exactly occurred to Feda Mullen. As a result of Brian Toft's report, some good stuff happened. But Feda Mullen suffered exactly the same fate as Dr. Bauer-Garber. So he was, this is the, oh, hang on a moment. So this is, sorry, this is the, some of the changes that occurred. So as a result of the Wayne Jowett death and the Brian Toft report, an organisation with a memory, the report of the Department of Health on learning from errors, was produced. That resulted in the formation of the National Patient Safety Agency, now defunct because it has been swallowed up by NHS improvement. And after very, very many years and endless wrong turns, that itself produced a technical solution to what has resulted in Wayne Jowett's death and the 13 kids before him, non-interchangeable intravenous and neuraxial connectors. So we now use connectors which don't cross over between the two. So you can't, if you've got a drug drawn up into a syringe which is to be given intravenously, it literally cannot be given intrathecally. But it's taken a very long time to do it. But all of these changes resulted from the outcome of the Department of Health inquiry led by Brian Toft, not from the prosecution of Dr. Mullen for manslaughter, and he was prosecuted for manslaughter. He pleaded guilty to it in absentia, despite the advice of his lawyers, and was sentenced to 8 months imprisonment, which ran concurrently with his sentence for assaulting his wife. He was a broken man by the end of all this. He turned on his wife and family, served his 8 months, and I've no idea what happened to Feda Mullen. I dread the worst. It's worth looking back at the organisation with a memory report. Remember, this was produced in, when was it, 2003, 2004? We believe that if the NHS is successfully to modernise its approach to learning from failure, there are 4 key areas that must be addressed. In summary, the NHS needs to develop unified mechanisms for reporting and analysing when things go wrong, a more open culture in which errors or service failures can be reported and discussed, mechanisms for ensuring that when lessons are identified, the necessary changes are put into practice, and a much wider appreciation of the value of the system approach in preventing, analysing and learning from errors. And here we are, over 10 years down the line, talking about Dr. Bauer-Garber, where every single one of those was ignored in her prosecution. We get worried about manslaughter charges, and I think understandably there was a literature review reported in the Journal of the Royal Society of Medicine in which Ferner and McDowell, who clearly had nothing else to do, went back through the newspapers to 1795 to find out how many cases of manslaughter were going on. And the graph they produced was pretty frightening, actually. And you can see the vast majority of the cases occurred since 1975, and there's a particular blip in the last few years prior to from 1995 onwards till the end of the report. This put for the Journal of the Royal Society of Medicine, which doesn't get much reporting normally. This made the press in quite a big way. They probably got it wrong. Looking at newspapers is not a good way of finding out how many manslaughter charges are going on. And then perhaps a somewhat better study carried out in March 2018 this year. This looks at referrals to the Crown Prosecution Service for manslaughter in medical cases. You can see there's quite a lot over the years. You go down to 2017, there's a particular blip in 2014, there's a high total as well, but nearly all of these were either investigated by the police and no further action was taken, or investigated by the police, reported to the Crown Prosecution Service, who took no further action either. That's still a pretty frightening experience. But you can see that by the time you narrow it down to those who had actually been prosecuted or which are still ongoing, there are relatively few. But still too many, I would argue. Why have we got this problem with manslaughter in England and Wales? And I say England and Wales for a reason. We rely on something called the Adamaco test. I'm afraid it's another anaesthetist, although I prefer to describe Dr. Adamaco as a doctor who gave anaesthetics, because he wasn't in any way a qualified anaesthetist, who left his patient in the middle of very, very many years ago. I think we're going back to the 60s. He left his patient in the middle of an ophthalmic operation, went off to have a cup of coffee, the tube became disconnected, and by the time he got back, and even the surgeon had told him the blood had gone blue, he didn't do anything until the arrest occurred, and he was found guilty of manslaughter. The test was the standard Bolam test for negligence, the existence of a duty of care, the breach of that duty, resulting in, or significantly contributing to, the death of the patient, for a patient has to die for there to be a manslaughter charge. But the extra test for that in manslaughter was that the breach didn't just have to be negligent, it had to be grossly negligent. And the whole of negligence, medical manslaughter history in the UK rests now on this test, gross negligence. And it's a very difficult test. How is it defined by the courts? Those people are very high intelligent to tell us these things. That's how they define grossly negligent. The circumstances of the breach were truly exceptionally bad, a phrase you've heard before, and so reprehensible as to justify the conclusion that it amounted to gross negligence and required criminal sanction. In other words, it's a totally circular test. It's grossly negligent because I said it was gross. That's all we've got. And that is understandably hugely differently interpreted by different courts around the country. And probably is the cause why we see so many cases which seem very unfair to us. There have been no successful claims for culpable homicide in Scotland, which is the equivalent of medical manslaughter, at all. There's been one tried which got nowhere. And in Scotland, as opposed to England and Wales, intentionality, recklessness and gross carelessness make up part of the test. We do not include intentionality and recklessness in ours. And also, even if all those are fulfilled, a prosecution of a culpable homicide of a doctor must serve the public interest or it's not pursued. And it may well be that we need to consider how we define gross negligence in the UK. It may yet happen. John Holbrook, quite rightly in the BMJ, described the criminalisation of fatal medical mistakes as a social intolerance of medical mistakes which has caused them to become criminalised. And as you know, the Williams report into gross negligence manslaughter, which was set up by the then Secretary of State as a rapid policy review following the Bawagaba scandal in June 2018, said much the same thing. A working group should be set up to set out a clear explanatory statement of the law on gross negligence manslaughter. We wait for that working group to be set up, and I hope it will come up with some sensible suggestions. In the meantime, we'll go back to my question. Oh, the answer, by the way, to the question, how do lawyers sleep at night, is first they lie on their left side, then they lie on their right side. But you didn't want to know. It's not true. It's not true. Are lawyers good for patients? I think my feeling is that civil litigation, although occasionally throwing up some useful information, is not good for patients in general because of the vast amount of funding that it extracts from the pockets of the NHS in doing so, much of which goes into the pockets of the lawyers. Criminal law, I think, is undeniably bad for patients. None of us are going to be better doctors as a result of fear of manslaughter charges. All we're going to be is more frightened and more timid doctors, and I don't think that's a good thing. It is possible that coronial law does come up with some good stuff which is useful to us, but on the whole, most of our lessons nowadays come from much more structured reviews than a coroner can achieve. Human rights? Ugh. I don't know really, probably not. But don't listen to me on this subject. That's what I wanted to say to you. We have much better speakers who know much more of what they speak. So on the 13th of February next year, you will hear from, God, he looks particularly good in that photograph. Damn, he doesn't look that good in real life. Bertie Lee, who is the senior solicitor at Hempsons. Hempsons are one of the few companies, firms of lawyers who are allowed to conduct or to defend the claims to the National Health Service Litigation Authority, as was. But has also been the first non-medical chairman of the confidential inquiry into patient outcome and death, and now sits on the GMC's working party reviewing medical manslaughter for the GMC, and is, on top of all that, a funny man, but most importantly, a mesmeric speaker who never used a slide in his life, and he will keep you absolutely enthralled. But before him, we'll be welcoming next month Rebecca Schiller on the human rights front. Rebecca Schiller is a lawyer and a doula, look it up, and she is also the Chief Executive Officer of Birthrights UK, which is a charity founded for the support of human rights in childbirth, not just in the UK but worldwide. And she's written a book which I recommend to you all called Human Rights in Childbirth. She is also a wonderful speaker, and I'm going to be inviting our colleagues from the midwifery profession to come along and join us for that talk as well, because Rebecca's got some good stuff to say about human rights, including, for example, the right of a woman to choose to have a caesarean section against her obstetrician's best advice. So I will leave you with those pictures, and thank you very much indeed.